Started. There's always something. There we go. Okay, lots of admitting people coming in. All right, so now that we're recording, good morning and welcome to Coaching Tango 2. I'm MJ Porches. I'm a broker, certified coach, and trainer and educator, and I absolutely love what I do. And Coaching Tank is a group that I have formed with my partner, Felix Hung, and we are here to train on a weekly basis. We are training at all levels, taking you from the surface level as deep as you want to go to have an amazing business. And I've been in this business for 34 years, coaching and training, and I want to welcome all of you that are new to the group. This is a free class to help you see and understand what we do here, and hopefully you will see the value that we bring on a weekly basis, and you'll want to come and join us for a low $96. That's it. The rest of this year, 6 months, $96 every single week. We're teaching and training, and it's on all different levels, from being a new agent all the way to be a $30 million producer. All right, so as we're specializing this particular month, it is all about what are your specials and what are you specializing in. Many of us have always wanted to have a really good understanding about probate, about understanding trusts. There are so many different scenarios and questions and things that come about with this, and it can be very confusing. We're not attorneys. Disclosure, I'm not an attorney. And unless there's any other attorneys here in the room other than our attorney that's with us today, you're not an attorney. And so they're the specialists, and they're the ones that are here to help us understand things at a different level. And so I'm going to bring on some introductions and share with you who's here, and then I'll turn it over so that they can put their information on the screen. We have Kim Allen this morning with us. Wave to us, Kim.
Good morning, everybody.
She's an escrow officer with Worldwide Escrow Services. How long have you been in business, Kim?
I've been doing escrow since I was 35 years. So a little close, 35 years. And I still absolutely love it. I love helping people, and I'm glad to be here.
Wonderful. It's great to have you. And so having your escrow officer have a great understanding of this process is super important, correct? It's super important. So we have her here with us as well. And now I'm going to introduce you to Mr. Marcus Hawkes. He is one of my most favorite and preferred title representatives in this industry. He's with Western Resources Title, and I'm going to turn it over to him so he can introduce our guest today. But make sure you have a pen and a paper, and that you're ready to take some amazing notes, because even though it's recorded, there's going to be some things that we're going to go over with regard to scenarios. So Marcus, welcome. It's great to have you. Please
thank you, MJ.
Today.
As always, thank you for the great opportunity to serve you and to take care of situations that we find ourselves in. I'm seeing more and more in my 18 years of being in title that we're learning something every day, because things change. Our business stays the same, but things change in terms of the housing market, and of course, in terms of legal situations. I have invited two of my really close friends and working partners. One is an actual colleague, and the other one has become a colleague over 12 years. The first one is my colleague of 18 years, is Gabby Igareda. She's our senior commercial and residential title officer. She's come up in the ranks. She started off, in customer service, and she's made her way over to being one of our top title officers. And the other person who has become a colleague, since I met her, is Tracy Kaiser. She's an attorney. She's an estate attorney. And I am going to let you know that she is the best estate attorney out there that I've found. And I can say that because I have I've referred her to many people, and she has really helped out. She has the heart of gold. She has a real estate experience herself. She was a realtor, and she also has title experience. So she's the trifecta when it comes to helping you with estate, with an estate problem. I'm also going to introduce you to Kim Allen because I think we've worked in the past. We've closed so many. She knows my former title officers, and she's one of the best in the business. And the reason that she's been asked to join us in this is because we are all going to share experiences. We've come up with scenarios. Now, the topic is probate and trust. And in my 18 years, I've been to many probate discussions. I've been to many trust discussions. And what happens, it winds up being one speaker and then people nodding off and not really grasping it. We came up with a really clever way of grasping everybody's attention, and that is by discussing probates and trusts within the lens of transactions and files that we've seen, nightmare files, transactions that have gone south, or transactions that have need to be resurrected so that you, hardworking realtors, can get paid. So when we put it under the lens of that, not only do we enlighten everyone, but we all learn about the tricky complexities there are in a probate and what causes a probate, but also the importance of doing proper estate planning. So you're going to get a lot. So we're going to look at it under the lens. So without further ado, let us look at understanding the chain of title. That is what we're doing. Now, when you bring, and where these probate and trust issues come up are always during a transaction. And they surge because of problems within the chain of title, within the time of ownership that a person has bought, that has lived in their property. Now, I want to show you what we do as your professionals, and escrow is involved in this. When we see these problems arise, it's when we're trying to do the right thing. We're trying to pass property over to a new buyer. So our goal in the whole transaction process is to go from this, where we're going to look at a chain. Here's the house in question, and it's in red. It's a red open link because it has a lot of fiery stuff that needs to be put out. When we go through the transaction and when we insure it, we close the chain of title. We close that chain successfully, and we add to it the new link that is open to encumber all the things that it's going to encumber, to be used with clear and marketable title. Now, a more vivid picture of that is this, the title insured property. When a property has been insured, it's cleared up all that red stuff, all right? And it starts off with an insured grant deed and a deed of trust, which is the instrument that records a secured loan onto the property. These other things are part of the property: easements, CC&Rs, property taxes, special assessments, encroachments, supplemental taxes, mellorues. Those are things that come with a property. When a property is in escrow, we see what happens after that property was insured. And this is all that accumulates onto the property. We have the same easements, CC&Rs, property taxes, those encumber the property. Those come with the property. Then you have that insured deed of trust when they bought it, when the person bought it, when the sellers bought it. And if they are still financing, those are going to be secured to the property. But then you have events and events that have been recorded onto the chain of title: uninsured quitclaims, transfers of ownership, NODs, NOTs possibly, mechanics liens.
You want me to keep reading?
I'm sorry, mechanics liens, judgments, credit card lawsuits, spousal child support liens, bankruptcy, lis pendens, and probates. Now, this is what is put on a prelim at what needs to be either paid off, signed off, accepted by the buyer before we can go back to this, the title insured property. So now what we're going to do is we're going to discuss discoveries that we've made during a transaction. And it's going to lead us to the discussion, the broader discussion of probates and trusts. So we'll start with scenario number 1. In 2018, Laverne Baker, recently widowed, refinances her home of 26 years and borrows $120,000 for her husband's funeral expenses, as well as roof and plumbing upgrades to the home. To qualify for this loan, she adds her sons, Damian Baker, a single man, and Daryl Baker, a single man, all as joint tenants. In early 2019, Damian marries Connie Hale. He moves out to start his family with Connie, and in August of 2019, he quitclaims his interest to his mother, Laverne Baker, a widow, and brother, Daryl Baker, a single man, all as joint tenants. In March of 2020, at the start of the pandemic, Laverne, now age 62, takes early retirement from 31 years of work as a teacher's aide. She and Daryl, an independent contractor who likewise is suddenly out of work, apply for forbearance relief and are granted 90 days of forbearance. In November of 2022, Daryl, still unemployed and uninsured, is in an almost fatal motorcycle accident. He is rendered paraplegic and permanently disabled. At the start of 2023, Laverne is forced to take on part-time employment to make house payments and pay Daryl's surmounting medical bills. She now needs to sell the house. So, over to you, Gabby. What would we require on what would be the problem here if one of these agents took a listing and we open up escrow or we open up a prelim? What would we need to what would we be needing?
So the first thing we have is an uninsured deed. The uninsured deed is the deed which Damian transfers his interest to Laverne and Daryl. So with an uninsured deed, we always ask for an uninsured deed affidavit at the time of any new transaction. We have to verify that Damian was aware of what he was signing. We have to verify that he is aware that there is a new transaction and he is no longer entitled to the property. So we would be requesting an uninsured deed affidavit for Damian to sign. Now, since Damian is also now married, we would also ask that his spouse, Connie, sign an interspousal deed because we want to make sure we cover any interest that she may or may not have or may feel she has. That would cover Damian's interest. Now, with Laverne and Daryl, that one's going to be a little bit more complicated here because Laverne is looking to sell the property and Daryl is now not able to handle his own affairs. We would actually require that Daryl or that Laverne seek legal advice and possibly obtain a conservatorship for Daryl's interest. The conservatorship would then allow Laverne or another party to act as conservator for Daryl and would allow them to then sell the property. Okay. It's really important that if you do end up in this situation, that once those documents are sent in, that they're sent into title for review to make sure that once they're received, they were done correctly, that Laverne has full authority to sell the property for Daryl's interest, and that we obtain the right documents to record against the chain of title to clear Daryl's interest.
Right. Now, Kim, over to you. If you see a contract that has been signed or an escrow contract, is there a red flag that you see if you were to see this?
On the prelim, I mean, absolutely. I would be checking the title from the time that the vesting deed comes in, even before we get the prelim, to say, let's say Laverne is the only one signing the contract because her son could not, and she's thinking she has the ability to sign on his behalf. I would be saying, where is this other party? What is the situation? And in my case, because I am that middle party, I work very closely with title to ask, hey, this is the situation. This is what I see. What is it that you want? Even though I know that it is a conservatorship situation, I'm not going to make that call for what your position is. But
Right.
I will work very closely and say, can we do this? Can we do that? I will always be asking those questions just from the experience, and
Right.
every circumstance is different.
Right. Now, Tracy, over to you. Now, first of all, the timeline for a conservatorship and what could have been done to avoid this situation.
Okay, so interesting. Can you guys hear me first of all? Want to make sure you can hear me.
Yes.
Okay. Gabby's got it right on. You have to file for conservatorship. And the thing that's, when you get real estate agents involved and you're wanting to open an escrow and you're ready to kind of transition to sell a piece of property, and all of a sudden you can't do that, and you have something like a conservatorship, and I'll give you a real life scenario of this too. You're stuck having to wait for a court filing, number one, and the attorney needs to prepare for a general conservatorship filing, and most likely what's called a temporary conservatorship filing, because if somebody is unable to take care of themselves and you've got real property that you need to sell, because the court system is so long, you're not going to be in court for probably 3 to 4 months in a general conservatorship, from the date of filing to the date of the hearing and getting approved. So I just had a situation like this, but the thing about this is if we wouldn't have had a revocable living trust and the asset was in the trust, we would not be in a conservatorship situation. Now, interestingly enough, Mom would still need to get a conservatorship for Daryl because she wouldn't be able to make medical decisions for her son. She's got to have that power, but her ability as a trustee, or the person who's the trustee of the trust, would be able to sell that asset right away and just smooth sailing. In a conservatorship situation, I just had a really interesting case where a gentleman had a stroke and he couldn't even move, couldn't communicate, and the wife had to sell the house. In a conservatorship, besides the timing of the emergency conservatorship and then the general conservatorship, courts will not approve the sale of real estate without court confirmation. So when you have a probate, you might be able to get what's called full authority to sell the property so that real estate agents can kind of do things as normal. Not in a conservatorship. The judge will say, you must come back to court. So you got to find a buyer. You got to publish in the newspaper. You then have to apply to the court for confirmation of the sale. Then you've got to go back to court and have a procedure where the court allows for overbidders on the conservatorship. The amount of time it takes between what we could have done between selling it in a trust and then selling a conservatorship could be as much as 3 or 4 months. So it's really complicated, and it's everything in a trust, smooth sailing.
Right. Just as a show of hands, how many of you have been faced with people that ask you, how do I put my son or my daughter on title? I bet plenty of you get that all the time. All right, next scenario. So this makes you think. This makes you think of what to respond to folks. Scenario number 2. In 2008, Jose and Lucinda Garcia, husband and wife, community property, form a living trust. As trustees, Jose M. and Olivia Garcia, they deed their property into the Garcia Family Trust. In 2010, Jose M. passes away and the title is changed to Olivia Garcia, surviving trustee of the Garcia Family Trust. In late 2019, Olivia's health starts to decline from Alzheimer's. Stephen Garcia, eldest bachelor son, as his mother's main caregiver and successor trustee of the trust, is somehow advised, and footnote that, I'll footnote that later, is somehow advised to have his mother resign from the trust. With each of his siblings' approval, he then deeds the property out of the trust and grants himself and each of his siblings, his 4 siblings, a 20% undivided interest in the property as tenants in common. In January 2020, Mrs. Garcia passes away peacefully at home. Because of the pandemic, Stephen, who resides at the home, and his siblings postponed selling the property and recording the affidavit of death for Mrs. Garcia. In the meantime, they share in the cost of making several improvements to the home. In February of 2023, the family puts the property on the market. 2 days after the home is listed, the youngest brother, Alex, one of the tenants in common, dies suddenly. All right. Again, Gabby, where are we with this one?
So we also have 2 scenarios here. The first one would be a little bit easier to clear. So you have the interest that Olivia Garcia had in the Garcia family trust. Because, again, that deed was done via an uninsured deed, we have to verify that everyone entitled to the trust was aware of the transfer into the tenants in commons for the 4 siblings. So as title, we would be asking you for a full copy of that trust to verify who the successors were, who the beneficiaries were, and verify that we do in fact have only 4 people as beneficiaries, and that there's not another party out there that will come back later to us and say, hey, my siblings left me out of this. So we would be verifying that interest. And the next part would be Alex. Since Alex suddenly died and they held tenants in common, we would require documents for a probate to be done for Alex's interest. Now, depending on the type of probate, we would advise in title what documents we would need.
Tracy, over to you.
Thank you. Gabby, again, I think she is a little bit of a lawyer, knowing what to do. Yeah, so the interesting thing is you have 4 people who own property as tenants in common, 4 siblings. As long as those 4 people are alive, then we don't have any problems going ahead and selling the property. Those 4 people, because they own an undivided interest, they have to go into escrow, and all 4 would have to sign escrow documents. As soon as one person passes away, guess what? Their 1/4 share, now that it's not in a trust, is going to be probated. So the escrow stops. All of the other 3 siblings do not get the ability to sell the property. They have to wait for Alex, either his heirs, could be a wife, could be children, to probate his estate. His estate will then go from him down to his heirs. It's either going to be a surviving spouse, or it's going to be, it could be children. If there's no children or no spouse, it goes to his siblings. So we're in a holding pattern again. And guess what? We probably wouldn't be able to close escrow on that at least for 2 or 3 months into the probate. We're in this 3 or 4 month holding pattern sometimes again in probate.
Right. So here's some other things too that Tracy and Gabby didn't know, and possibly Kim, if she would have asked her, didn't know what happened in this situation. In this particular situation, yes, the probate was done. After the probate was done, and well after the year that the probate closed, they got the heirs, or the one who was assigned as the administrator for the probate, the successor trustee, got a tax bill from the time that it was a supplemental tax bill for property taxes from the time that Mrs. Garcia died to the time they sold it, because of that. So very important to know. Go ahead, Tracy.
Well, it's interesting because she passed away in 2020. and they didn't sell the property until 2023. And I'm going to assume that the property value increased dramatically. And so what you're dealing with when a person, just for the agents to know, when a person passes away, you lose your Prop 13 back when we had it, your Prop 13 exclusion, because the person's not alive anymore. They don't get that, they don't get the benefit of having that initial basis when they bought the property. So all of a sudden, now the property, as soon as they die, is exposed to an increase in value and an increase in the supplemental taxes. So even if the property is an inheritance, you may have two issues. One, you may have capital gains, but as an inheritance, actually there still may be capital gains, but on top of that, you have a supplemental property tax bill because of the increase in the value of the property after the death. Just a little aside.
Right. So, and then now with Proposition 19, where, and it was highly supported by realtors, but it's kind of stabbing you in the back, because now with Proposition 19, it repealed and replaced Propositions 58 and Propositions 193, which were the parent to child and the grandparent to grandchild transfers. Okay. And so it repealed those. So you cannot pass that on to heirs. You can only pass it on to one heir if that heir is going to remain in the property and claim it as their personal residence. Regardless, when somebody dies, well, first of all, the main message here is get your properties into a trust and do not take them out. Get your properties into a trust. Instead of taking that trip to Cabo San Lucas, that money, if you don't have a trust, needs to go to put your property in a trust. I, as a single man, bought my first property a month after moving into my property. I had my property in trust. I do not have any heirs but my nieces, but I do not want to give any more money to Uncle Sam than I need to, right? So it's the most secure. Now, the other thing too about this, Stephen Garcia's cousin, a realtor come lately, was the one who advised him to take it out of the trust and distribute it equally to the heirs. All right. If ever you hear any of your colleagues say, well, take it out of the trust, you really, you need to stomp that fire, put that fire out before it begins. Put that fire out. And yet, no, you cannot advise on how one should take title. You cannot advise on that. But you can advise every day, 24/7, twice on Sunday, about the importance of working with an estate attorney. You can always advise them to work with an estate attorney and to put their property into a trust. It's one of those things where you can always advise. So those are just a few little asides in the importance of estate planning and the importance of understanding how property taxes work. So if you are if one of your parents or some of your loved ones have a trust, and God forbid they should pass, make sure that in a timely fashion, you check with the tax assessor's office and find out what you need to do to avoid an escape tax. How much time you have for that to happen. In Los Angeles, you're given 150 days to report the death of a home property owner. And they have the paperwork, and they have instructions, clear instructions. They give you 150 days to report that so that you will escape an escape tax. And so that you can, and it actually guides you as to what the timeline is that you have for selling that. And they also they're also providing information about Proposition 19 and how that's going to work with your given situation. So on to the next scenario.
Can I just make a comment about that real quick?
Yes,
about
Kim.
the trust. In most situations, yes, put it in a trust, don't take it out, but you're going to find situations, even as a realtor or a friend or someone that knows you, that when you go to refinance, in most cases, they pull you out of the trust to
Right.
get financing. So it's just very important that you advise them to put it back in the trust, because they're just going along with the paperwork and they're not experienced every day to say what, they're not really understanding that they took it out and that they need to put it back in.
Kim, excellent, excellent advice. Now, I'll add to that. I've refied my house 3 times since I bought it. And each time I have insisted with the lenders, and actually it came from the first lender who that I refied with, who said, no, we're going to keep it in the trust because they incorporate an affidavit. What do they incorporated a certificate, a trust certificate into their paperwork. So whenever you're recording the deed of trust, they'll also get a signature and have a notarized certificate of trust. In other words, to explain to the underwriters that I am one and the same with the owner who's trying to, owner of this trust, who's part of the trust. So, but you're right. In others, there are some banks that still want you to take it out of the trust and put it up, but most institutional lenders are now allowing, they are adding a trust certificate into their paperwork so that you don't have to take it out of the trust. It'll go back into the trust after they secure the loan. So, but it's very important that you check whenever you're refining that if you have property in a trust, that it's going to stay in the trust.
Yes, and especially, it's having somebody experience, and not to say that you can't work with people that are not as experienced. I mean, everybody starts somewhere, right? So you might have a loan officer that doesn't know that. So it's important that you know that, so you can ask those questions and say, well, why can't we stay in the trust and why can't we? You know what I mean? Like ask those questions that would prompt them to ask their underwriters, what do you need to keep us in the trust? But if not, what do we need to, make sure that it's put back in the trust?
So it brings a question, Gabby, on a new purchase. If a person is buying the property and they already have their trust, can they purchase it with as individuals and have it put into their trust
After close? Yeah, we can certainly do that. A lot of the times there are lenders who still don't lend to trust. So you do see them purchasing as an individual, and once the file is closed, then they'll go ahead and record that deed, transferring the property into the trust. And we always recommend, of course, that they do it right away. We can't do it the same day that we close because we have certain terms we have to follow with the lender, but we can definitely do it a day after.
Great, good information.
Marcus.
Yes, MJ.
So before we get into scenarios 3 and 4, which I hope you guys are really grasping, even taking your notes with these scenarios, because the next ones are doozies as well. Comments that I want to make are, because we're talking about specializing, do you see that Marcus is not an attorney, but his knowledge surpasses and gives you the confidence that he understands this process. Forget that he's a title rep, okay, and that this is, he still chooses to know this and know it well, okay? That's a choice that he has made, to know it well, not only to serve clients and customers and ourselves. Gabby's not an attorney. Her knowledge of title, yes, it helps, but again, we're talking about specializing, right, Tracy? We're talking about having an understanding of it so well that we can speak about it and to it confidently, and then refer it back to the specialist and refer it back to escrow. And we need to be confident enough to reach out to these folks to ask them for the better understanding when we don't. Now, that's why we're talking about how we need to grasp specializing and grasping all of this understanding. But I also want to ask Tracy in a short nutshell, as we move into scenarios 3 and 4, Marcus, for when we do meet someone, Tracy, that the situation is already passed. We're going to meet those folks that, I'm not in a trust. I'm not. Oh, shoot. He has a will. She has a will. So before we move in, can you give us that, okay, it's now going into probate. What happens to me? And who gets, do I have any chance? Am I getting any money? Am I just sunk? can you give us a little bit of that probate understanding before we go into 3 and 4, please?
Okay, and yeah, absolutely. And what you're talking, let me make sure I understand the question. The question has to do with the fact that when you end up in that scenario, the family sort of panics and doesn't know what to do. Yeah, so here's one thing that my office does. I mean, we manage about 80 probates in our, like what we have right now going on. We do a lot of them. And the family, the one thing that a probate attorney can bring to the table is kind of being a calming force. Maybe hopefully give the family peace and hopefully give them direction on what they're going to be doing, because when a probate attorney gets involved, they take it from step 1 to all the way to the end. The thing about probates that I tell my clients is you don't ever have to go to court. You don't have to step foot in a court. You don't even have to talk to the judge. We do everything. And it's a matter of us taking it from the beginning to the end. The client, who's either usually a surviving spouse or an heir to the estate, just works with the attorney, signs paperwork, opens bank accounts, goes to escrow and does those things. But we hopefully are the calming force for the client. And I do know that a lot of times people have come to us and feel like a huge relief, because they now go, okay, I don't have to deal with this. This is your problem. You deal with it. Just tell me where to, when to sign and where to sign. And we use DocuSign now, so it's even simpler.
Wow, that's excellent. Thank you for that. Just to kind of grasp over that a little bit, Marcus, because we're moving into these other really deep scenarios, and people do panic.
Right. I will say this, I will add to that. I've had personal family that found themselves, my cousin, her husband, his mother passed away, and they found themselves in probate. And I sent them over to Tracy, and they still talk. They live in Oregon. They were down here for the sale of their mom's home. And they refer to, she just takes care of it for you. She explains it all to you, and it's a seamless process. And I don't know of very many attorneys that make it that way. Similarly, we had someone in-house. One of our colleagues, her daughter's father, or her ex-husband, died intestate, and so she helped Tracy helped them with that process. And it's like she says, they go to the office, they make an appointment, she tells them what she's going to do for them, and they leave with a big sigh of relief, and they leave it in her hands, and it gets taken care of. So that's and they understand everything that's going along with it in terms of timeline. She's very clear on her timelines, and she turns into escrow and to title very clean paperwork that we need for closing. So let's go on to scenario number 3. In 1986, Robert and Susan Lamb and Susan's aunt, Myra Chow, acquired property, full sale transfer, as Robert Lamb and Susan Lamb, husband and wife, and Myra Chow, a widow, all as joint tenants. In 1998, John and Susan form a family trust and sever their joint tenancy with Myra Chow by vesting their interests as Robert Lamb and Susan Lamb, co-trustees of the Lamb Family Trust, dated 1998. In 2000, Susan Lamb records an affidavit of death for Myra Chow, who died August in 1999. In 2002, Robert and Susan Lamb take their interest in the property out of their trust, invested as Robert Lamb and Susan Lamb, husband and wife, as joint tenants for a refi. In 2003, Robert and Susan Lamb refinanced their home for $151K. The lender secures the transaction with just a loan title policy. Their 50% ownership is not questioned, nor do they vest their half interest back into their trust. In 2021, Susan Lamb signs an independent solar energy producer contract with Sunrun Incorporated. Last week, Susan takes a nasty fall and breaks her hip. Her nephew and the Lamb's only heir, Jason Chow, contacts his realtor friend to list the property. Jason informs the realtor that his uncle, Robert Lamb, died in April 2020. This is one of the most disgusting files I've ever seen.
Oh, what a mess.
Wow. Wow. Wow.
But it happens. Gabby, over to you, because you're the one that's going to point out.
Talk about putting me in the hot seat.
Help, Gabby, help.
Okay, so you obviously have several situations here. The first one, when they transferred over to when Robert and Susan transferred over into their trust, they severed the joint tenancy that they had with Myra, which now brings them to have an interest as tenants in common. So the interest would be Myra Chow as an individual and the trust. Those would be the two interests on title. Then the affidavit of death that they recorded for Myra, essentially it does show the assessors and anybody that looks at title that Myra is now deceased. However, her interest needs to be probated. Because they severed the joint tenancy, we would actually look for a probate for Myra's interest, because we don't know if she has any heirs. Does she get married? Does she have children? Does she have nieces and nephews? So we would ask for her interest to be probated. Then you have that refinance, that doozy refinance that had no title insurance, which means nothing was verified. You now have a secured loan. However, you still have a cloud on title because of Myra's interest. So then you have the interest of, now you also, so you do have that probate for Myra. Then now you have Susan being disabled. And I don't know the exact scenario with her, but was she incapacitated? Was she able to sign or was she not able to sign?
She was able to sign.
She was able to sign. Okay, so if Susan is disabled, but she is able to sign, then she can go ahead and try to sell the property. However, she still would need to clear Myra's interest because she doesn't own the property outright. Myra's interest is clearly still on the property.
Right.
And so if she weren't be able to sign, you'd have a bigger trouble, obviously, because now you also need a conservatorship for Susan. Now the question here is Jason Chow, he's a nephew who listed the property. And the question would be, who is he? Why is he listing the property? Where is Susan? If Susan can sign, why is she not involved?
Right.
So if Susan is able to sign, she's capable of signing, she's aware of her surroundings, then we would definitely make sure that Susan is involved in the transaction. Jason can, maybe be a part of and helping his aunt, but however, we would require Susan to be involved.
So I bring those 2 points up to direct some questions to Kim, because a lot of times people think that title sees the contract. And here's a big reveal. Title rarely ever sees the contract. We do not need to look at the contract to understand anything. So I put that on there because Kim would get this and she would have those same questions. Who is this guy, right? And the other question that we usually get with this, with situations like this, how does a power of attorney work? Okay, because that's the first thing. The other reason, and we'll talk about that after, but I want to direct this over to Kim because I put the fact that there is a solar energy contract in there because I want to, that in addition to a probate situation, those solar programs tend to be a little, can be tricky sometimes. How would you, first of all, handle the part about the nephew coming on there. And then once you see that on a prelim, that there's a solar energy what are some tips that you can give our agents for clearing up that that solar?
Yes, definitely tips, not advice, but I would be looking at it and I would be saying, okay, who is our guy, Jason? Why is he signing our contract? Okay, your aunt is sick, but is she incapacitated? Those would be the questions to reiterate. Can she sign? Then I'm sorry, you cannot sign. This contract is not valid. You need a new contract where she's signing on their behalf. So it's just always pointing back to the way they hold title, because I don't even see a prelim yet. I just see the last vested deed. So that's where I start as soon as escrow is open. Like, you don't have to wait for a prelim, although the day and age we're in, we do strongly, not using that advice, but saying, hey, in my experience, let's pull the prelim before, so we're not having all these surprises at the last minute, so we can see really who is on title. But sometimes you may not have the whole scenario either until you get the contract and see that Jason is really the one signing the contract. So it's just reiterating to them that, and us having the experience to know, when we're looking at it, this is not the same as what your contract is saying. So we have to just look at that full picture before we have the full picture. There's a lot of information you could get by just looking at the last title vested deed.
Right. So this leads me back to exactly. So two things that I want to add to it. This is why it's so important before you're going on a listing presentation and well before you get into escrow, that you order a property profile from a title company with the docs, not one that you get online, not one that you get through Realist. I cannot speak for the accuracy of Realist. People think that, that's what it says is gold. There's the way that I define it is Realist, I am told, is realtor reported information. The information that you get in a property profile is tax assessor recorded information. Big difference. And we all share those little programs that you can get profiles from, those Title Pros and those, that's not the same as ordering a property profile from a title company's customer service, because they're going to have actual eyes, human eyes, looking it over and figuring out the chain of title. So always, before you take a listing, before you even go on a buyer's consultation, get a property profile with the docs that has been searched from a customer service. And I guarantee you, no title company is going to balk at the fact that you do it all the time. You need to do that. I always tell my clients when they call me and they talk to me about a situation, did we do a property profile? I need to review the chain. And your title reps and your title reps that that know this stuff, they're always going to insist that they want to review the chain. Any property profile that is sent out for my clients, anyone, I get a copy of it. I always review the chain. That way, when we have these questions and we haven't run the prelim, I can tell escrow. Escrow, we have, Kim, we have these certain things that we need to figure out. I think it's a possible probate. I'm going to go ahead and order the prelim for this listing, assuming that you've taken a signed listing. And I'm going to reference you as the escrow, because what we do in title is we just report. The person that helps us clear up all these problems is escrow.
Right,
So,
like we're the bridge there.
Exactly.
We're that middleman that is working on your behalf and then working with the experienced title company to bring it all together. So I don't just make those decisions. I contact title, but with the experience, I can look at the chain of title and say, oh, there's a lot of stuff going on.
And if it's a file that calls for probate help or help with a trust, we know that because I've already gotten the property profile, I've reviewed it, I've talked to escrow, we've opened up a prelim. Now, if it does in fact require probate, then I have that full file of input from escrow, input from my title officer, and we send it over to Tracy, and Tracy's going to be able to do her stuff lickety split. So it's very important that you understand the importance of understanding the chain of title, and what you don't understand, seek us. We can help you navigate through these questions. I also want to mention about powers of attorney, and I have a lawyer here that can help me back this up. Okay. There are times that you get, I get questions from, in my 18 years, every year, I think, or maybe twice a year, I get questions of power of attorney. What a power of attorney, durable. Well, they have durable power of attorney. I always look at that and I tell them straight off, I tell all my clients straight off, the only time a title company and an escrow company, for that matter, are going to accept a power of attorney is in specific instances of absence. Specific instances of absence. One of the spouses is going to be deployed. One of the spouses at the time of signing is going to be away in Turkey tending to their sick relative. Never is a power of attorney going to be used for title insurance in someone's demise, incapacity, or in conjunction with the trust. So you may be a successor trustee on a trust coming to and saying, well, my mom, I'm going to use the power of attorney. No, power of attorneys are only specifically used in a transaction in questions of absence. All right. Anything that you would like to add to that, Tracy?
I mean, powers of attorneys they're sticky things, and banks. So for a title company, a power of attorney may only be used for limited purposes. A power of attorney presented to a bank goes through a legal process, the legal department, the process of being reviewed and being approved. And usually that's for heirs or for people who need to do banking for their family members, to have the ability to write checks, those types of things. They'll use powers of attorneys for that. In our scenario, when Gabby said, who's Jason? The interesting thing is it's possible Jason produced a power of attorney. And a power of attorney, him thinking that the power of attorney would allow him to stand in Susan's shoes, which I suppose it could, that could possibly, I mean, if the title company accepted that, that's possible. We always want to go back to the source, which is Susan. And if Susan has capacity, then we really don't want to use the power of attorney. We want to use Susan. So Jason might be thinking he's doing a great thing, but Susan's a person who, if she has capacity, we want her to step up. So I always tell my clients when we do an estate plan, the power of attorney is included, but we don't really, it's not really used unless it's absolutely needed for certain circumstances.
Yeah. Sometimes I hear, well, mom is going in and out of Alzheimer's. She's not there. And it's going to be a cash deal. So 10 days. And I said, well, okay, sure. I'll pretend that I never saw it. I'll pretend that I never saw it, but doing that is doing you a disservice, because let's say you get through the transaction and later proceeds are given to her, and you're going to be, you have an heir who sees that you did this all through a power of attorney and not through a trust. Who's going to help you during that lawsuit? Not that power of attorney. It's certainly not your title company.
Yep. And here's something to think about too, is just going back to the scenario. Myra, if Myra's not related to Robert and Susan, before we can close escrow, we've got to find somebody to probate her estate. Robert and Susan wouldn't naturally probate her estate. So we've got delays. What I'm speaking in terms of is the delay issue. which is we've got to find an heir to Myra. We have to find somebody who would would be the person that would do the probate. And sometimes that takes time as well. And then last thing, in this scenario, the solar companies, they usually don't like the buyers to take over the solar payments. I think they usually, I don't know, Kim, you can speak to this. I think they usually require the seller to pay it off.
No, that's not necessarily the case. I think every
Okay,
scenario is
okay.
different and every solar company is different.
Okay.
So right now, there's a lot of transfers.
Oh, good. Okay.
You know, some of them are paid off. And then, so it's just a different situation for every
Okay.
scenario,
Well, that's
depending
good
who
for
the
me to
company
know,
is.
because I didn't know that. Thank you.
But it does
And
need to be cleared.
And I'm conscious of the time, so
Yeah, ding,
we
ding,
don't-
ding, ding.
we don't really need to do scenario number 4 because it's a little bit more of the same. So I'd like to use these last 4 minutes to see if anybody has any questions that they would like us to answer, anything that either scared you or caught your attention.
I have one question in the chat. I'll just reference it here from Deborah, unless you want to unmute Deborah, but she had put in durable power of attorney, Tracy, will need a written statement from primary or specialist who cares for the owner or tenant in common is not in physical mental state to handle their own affairs.
Usually when you have a person who, first of all, the power of attorney usually is used for people who still have capacity. If we're needing a doctor to do a written statement to show that the person doesn't have capacity, then usually we're going to go back to the revocable living trust. We hope that there's a revocable living trust. And we're going to look to the person who's this next successor trustee to step up and stand in the shoes. Because usually when somebody is incapacitated, they don't sometimes regain capacity. And so if that person is not going to regain capacity, the person who's named the successor trustee will continue to be the trustee for the rest of that person's lifetime.
Now, I've been there where title required copies of the trust, living trust, the will, any power of attorney that we had, and a letter from the physician. It told them that the daughters could take over and sell in his best interest.
Well,
Right.
you have legal documents that will allow them to do that. They may not have relied on the power of attorney. They may have relied on the trust.
Mhm.
Right, well, they wanted the whole gamut.
Oh, yeah,
So
yeah. Every
Yeah.
company's different.
And see, you will see a power of attorney associated with the trust. Correct me if I'm wrong. So to establish those powers within the pour over will of that's
Right.
part of the trust.
So at that point, at least in our underwriting guidelines, if we were to have a trust involved, we would actually follow the terms of the trust, require the physician's letters to verify, and we would have them sign off not as a power of attorney or an attorney in fact, but we would actually have them sign off as the successor trustee at that point.
Yeah. Maria, you had a question, Maria Pulido?
She did. I'll go ahead and read it unless she wants to put herself on camera and ask. This is a coaching group, so camera's on. What is the difference between going through a probate with an attorney or a paralegal, Tracy?
You know, I had a client hire me because she hired a paralegal, and the probate did get kind of messed up. So they came back to me and I kind of had to take over to fix it. There are probate paralegals who do nothing but probates. And if you can find a good one, I say more power to you. Go through the probate with a paralegal as long as they're giving you advice. Here's the problem is when you have a probate, you have, or in any filing, you have all these variables, whether it's other family members who hire lawyers to then litigate inside of the probate or to object. You have creditors where there's creditors claims and you have to negotiate creditors debts. You have to make sure that you give notice in the newspaper in the very beginning of the probate. You have to publish in the newspaper. The amount of work that a probate attorney does, I don't even want to begin to tell you guys how much work we do. And it's not just pushing paper, it is time consuming. We you know, we earn our living, when we do this stuff. So a paralegal, they may not know all those processes. And then what it does is it delays the probate. I've seen probates, people come to me after 1.5 years of being in a prolonged probate because the judge says, okay, I'm continuing this. And you know what, when the judge continues hearings, it's not 1 month, it's 3 to 4 months because
Mhm.
their calendars are full. So it just depends on the person if they want to risk it or not. I'm not saying a probate paralegal is not helpful. They could be very well. Just depends.
And I will add to that, that a good probate attorney has a good paralegal.
Ah,
It's a teamwork effort.
Yeah.
You know, Tracy has some great staff members, and they help her to, you know, to be able to do the process seamlessly, quickly, and and without that much stress. But they work really hard. So a paralegal, you get what you get. It's better to have the power of two, the teamwork, the paralegal being directed by the attorney.
Marcus, we have a question. Suzette, would you like to unmute?
Sure, thank you. I'm in a situation where my mom lives in Oregon, and she and my sister, she's disabled, but she's not incapacitated in any way. They're both on title of the house now, and my mom is not well. So I'm going up there this week, and my mom had a will that she had notarized, and she wants me to be her executor. She did this years ago. It needs to be updated because since then they moved, and I don't think it doesn't even include the house that they're in now. And so I'm thinking, well, I really think we need to get a trust set up, you know, ASAP, because she's in need of a triple bypass. And does the trust have to be done in the state that the property is in, or can it be done from here?
I mean, I think, well, you can do a California trust. And you can put property in a different state into a California trust. However, because she's in Oregon and she would be the grantor or the trustor and the trustee, I would think that she'd want to possibly, and Oregon is a different, I mean, she's probably widowed, so she's not married. But
right.
Oregon is not a community property state, it's a separate property state. So we've got different laws there. She would probably, especially if you're married, you'd definitely go to an Oregon attorney, not a California attorney.
Yeah, no, her late husband is already deceased, and they were separated before she ever got this.
I mean, my suggestion is you go to an Oregon attorney, you have the trust drafted in Oregon, and then if you need to be the trustee down in California, you can still manage the estate in California as the trustee for your mother.
Okay.
But I would stay in Oregon, especially if the real properties in Oregon.
Yeah.
Okay, and then they are on title right now as my mom's name as unmarried woman and my sister's name as an unmarried woman. And so I don't.
In California law, that's probate. That's going to be probate. If your mom passes away, you're going to be well. I guess I don't know if it's tenants in common. Unmarried woman. I don't know if it's joint tenants or tenants in common. It depends on how title is. If it's
in California, if you don't list a vesting, if you even put the husband's name and the wife's name, it's tenants in common. If you don't put married, sole, and or if you don't put community property or joint tenants with right of survivorship.
I mean, Suzette, go do a trust, even if it's a quickie one. I'd rather see you do a legal Zoom trust than not have one.
Right.
Okay. And then
you know what, I have some friends that know of a good attorney in Oregon. I have family in Oregon, so I will do some research for you.
That would be awesome. Yeah, because I'm going to be there for 17 days, and I really want to get it done while I'm there because, like I said, she needs a triple bypass, and right now she can't have it. So, she's kind of like a ticking time bomb. But we're just hoping that as she's quit smoking, that hopefully she'll get more time.
Okay. So what I'm going to do right now is I'm going to put my number here on the chat.
Yes, Marcus, can you put, or Tracy as well?
And I'll put Tracy's number on the chat as well.
Everyone is looking for information, so we want Tracy's information in there. Gabby as well. I know her information is right up at the top, if you guys can see on her screen. Kim, if you want to put your information in the chat, that would be great. I know that we have one more question. I want to honor that. Unless there's anyone else that has a question, please raise your hand. But Jeanette Ivada, are you able to get on screen and ask your question?
Hi, yeah, sorry, I'm driving. How are you guys?
Welcome. What's your question?
Thank you. So I'm a realtor. I was referred a property that unfortunately the husband passed away, and apparently the children do not want any interest. They're out of state. So my question is, what happens when the property's not in a trust or will? Where does it go?
Well, you're right in our sweet spot of probates. So is there a surviving spouse?
No, they're both passed. That's why I wanted to get your information and connect. I have two situations like that where the
Okay.
properties are just kind of vacant, and nothing's really happening, and the children want no involvement. So I just needed some guidance, and I wanted to work with you on them.
Yeah, just give us a call. Hopefully there's enough equity. Hopefully there's equity in the properties. And I will tell you, as soon as the children know there's equity, they'll be calling you.
Okay. Yeah, they're in prime locations. They're up in the hills. So I definitely am thankful for the referral, but I needed some guidance. So I'll definitely be reaching out.
So Jeanette, if you want to, I'll get your number through MJ, and I put Tracy's number, because I see that you're driving. We can get you a call back. All right.
Just a note too, this happened to me many years ago. Oh, when you interview for a listing, ask to have a copy of the trust and will. Because this happened to me many years ago, where two grandsons wanted to sell mom's condo in a senior housing development in Seal Beach. And they brought the will or the trust as well. And they were named, but only if their mother was not willing or able to. So here they were ready on the list without mom knowing that they were going to list. And they did not have the capacity to do it.
Right.
I asked, okay, I need to talk to mom, and they disappeared and never heard from them again.
And see, Deborah, that also brings me back to reminding you to get a property profile, because now that if you see that the property is in a trust, you know what to ask for, you know who to verify with, and you know how to answer these questions, with the help of your title person that's there to see these situations and guide you through them.
But like you said before, sometimes there is a trust, but the deed's never been filed. Either never has been filed or put back in after a refi. Because
Right.
it has happened where the deed in trust was never filed either by the people who have the trust or by the attorney. And believe it or not, it happens where the attorney was supposed to and they don't.
Right. Well, that leads us to scenario 4, but scenario 4 was a situation where the property was not put back into the trust, and they had to do what is known as a hexstead, which is kind of like a small probate to put it back into the trust. I do want to say this to you as well. Hopefully this has been enlightening to you, and hopefully this has gotten you to understand probates from a more workable and a more beneficial lens, because I know that the other probate presentations that I've gone to, I've been in company with realtors who want to get business from probates. And it really doesn't work that way. It's you find yourself in probate. So the takeaway that we want for you to have is to be able to recognize where there's a probate and to know that you're going to have people that are going to help you through it, so that you can bring help to those people who find themselves in probate, as opposed to being a ambulance chaser, for want of a better term, for probates, because that's the way that they've been presented at the different boards. And I've been in this business, people go to those and they're presented and they think, well, gosh, I really want to work with that probate attorney. Probate attorneys do not select realtors. They don't.
Almost
Can I
all my,
just bring one
yeah.
scenario?
Yes.
Can I bring
Yes.
one scenario? Because it's so prevalent in our industry of having an uninsured deed, and that wasn't one of the scenarios. But let's say the one person had passed away, you know what I mean? As far as the uninsured deed, that person passed away, but so you couldn't go back to get the affidavit of uninsured deed. How would you handle that as a title company? Because this happens every day. You pull prelims all the time. People transfer to their, sometimes people transfer 5, 6 times, and sometimes it's just one, but I think that's something we all could know, when they're referring their client to, or their client's asking, how can we do this?
We had a situation like that just the other day, right, Gabby?
Yeah, so we do require a copy of the death certificate. Once we receive the death certificate, then we will verify what was that person going through possibly when they signed the deed. Did they sign the deed and the death certificate says they had Alzheimer's or dementia? We look very closely into that. If the person passed and the deed was signed, a couple years back, we'll make the exception. We'll accept just a death certificate. And then, of course, we do have to verify the signature. So we'll start getting into asking questions. A lot of the questions stem from the death certificate. And in most cases, the death certificate is sufficient enough to pass on title.
Great.
Okay.
Wow.
And just to sum up, going back, Tracy, right? You don't pick the realtors with your probates. Usually probates are brought to you by realtors. So it's some really good information that you need to ingest, right?
Yeah. I wish I had the opportunity to give realtors more business because it's fun for me, but most of the time I'm the person trying to solve the realtor's panic problem and they want it done yesterday. So I'm constantly going ex parte for realtors, but I'm not real. So I'm trying to fix their problems. They come to me, we try to fix it. We try to close escrow, get them moved on. But if I have open ones, I would love to refer them. I just don't get a lot of them.
Right.
Yeah. Well, let me help. Thank everybody for being here. I know that this is the team that is going to support it in these types of questions. And if we want to become specialists in any arena, not only attending trainings is really important, but being able to have the right people on your team to back you up, to get you in front of other people and resources. Your title representatives like Marcus Hawkes is going to be able to get you right in front of the right people and the right resources. If you don't have anyone, obviously here in California, you want to reach out to him or Kim Allen in Rancho Cucamonga. He'll also connect you and she'll connect you with Gabby. And now we have a great connection with Tracy. But this is what this is all about here at Coaching Tango 2, is giving you guys that boost of oxygen that you need on a weekly basis. We do all kinds of trainings here. So we look forward to having you come join us. If you'd like more information on how to come join us, it is a membership and a group coaching that we do every week. And we will continue to have wonderful people like we did today. So I want to thank Marcus and Gabby and Tracy and Kim for your time today, for your insight, for your expertise. They're specialists in their field and you are a specialist as well. Just kick it up a notch and grab your awareness around where you want to harness your specialty and get confident in it so that you can start to help people recognize where they are and what their next steps are going to be. So if you got great value out of today, come join us. We'd love to have you. I just really want to say thank you again to all of our guests, everyone that joined us, Coaching Tango 2 members. We'll see you next Tuesday with another great class. Have a wonderful day.
Thank you for having us.
Thank you for having us, MJ. We really appreciate it. And give us a try, folks. We're willing to.
Thank you.
We're willing to help you.
Yes. God bless you guys.
Thank
See
you.
you
Thank you
soon.
so much.
Bye.
Thanks for
Bye.
being here.
Thank you.
Bye-bye.
Bye.